All right, welcome back to the Daily Facts. And we are into part 8 of the Sidney Powell, Georgia lawsuit. So let's get right into it. The court has held that to ensure equal protection, a problem inheres in the absence of specific standards to ensure its equal application. The formulation of uniform rules to determine intent based on these recurring circumstances is practicable and, we conclude, necessary. Bush versus Gore. The equal enforcement of election laws is necessary to preserve our most basic and fundamental rights. The requirement of equal protection is particularly stringently enforced as to laws that affect the exercise of fundamental rights, including the right to vote. In statewide and federal elections conducted in the state of Georgia, including without limitation the November 3rd, 2020 general election, all candidates, political parties, and voters, including without limitation plaintiffs, have a vested interest in being present and having meaningful access to observe and monitor the electoral process in each county to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. Moreover, through its provisions involving watchers and representatives, the Georgia Election Code ensures that all candidates and political parties in each county, including the Trump campaign, have meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. In plain terms, the statute clearly prohibits opening absentee ballots prior to Election Day, while the rule authorizes doing so 3 weeks before Election Day. There is no reconciling this conflict. The State Election Board has authority under OCGA 21 2 31 to adopt lawful and legal rules and regulations, but no authority to promulgate a regulation that is directly contrary to an unambiguous statute. Rule 183 1 14 0.9 15 is therefore plainly and indisputably unlawful. Plaintiffs also bring this action under Georgia law OCGA 21 2 522, grounds for grounds for contest. A result of a primary or election may be contested on or more of the following grounds: 1. Misconduct, fraud, or irregularity by any primary or election official or official sufficient to change or place in doubt the result. 2. When the defendant is ineligible for the nomination in or office in dispute. 3. When illegal votes have been received or legal votes rejected at the polls sufficient to change or place in doubt the result. 4. For any error in counting the votes or declaring the result of the primary or election, if such error would change the result. Or 5. For any other cause which shows that another was the person legally nominated, elected, or eligible to compete in a runoff, primary, or election. OCGA 21 2 522. Several affiants testified to the improper procedures with absentee ballots processing, with the lack of audible procedures with the logs in the computer systems, which violates Georgia law and federal election law. See also 50 USC 20701 requires the retention and preservation of records and papers by officers of elections under penalty of fine and imprisonment. The State Election Board readopted Rule 183 1 14 09 15 on November 23, 2020, for the upcoming January 2021 runoff election. A large number of ballots were identical and likely fraudulent, and Affion explains that she observed a batch of utterly pristine ballots. Most of the ballots had already been handled. They had been written on by people and the edges were torn. They showed obvious use. However, one batch stood out. It was pristine. There was a difference in the texture of the paper. It was as if they were intended for absentee use but had not been used for that purpose. There was a difference in the feel. These different ballots included a slight depressed pre-fold so they could be easily folded and unfolded for use in the scanning machines. There were no markings on the ballots to show where they had come from or where they had been processed. These stood out. In my 20 years of experience of handling ballots, I observed that the markings for the candidates on these ballots were unusually uniform, perhaps even with a ballot marking device. By my estimate, in observing these ballots, approximately 98% constituted votes for Joe Biden. I only observed 2 of these ballots as votes for President J. Trump. See Exhibit 15. The same affiant further testified specifically to the breach of the chain of custody of the voting machines in the night before the election, stating, "We typically receive the machines, the ballot marking devices, on the Friday before the election, with a chain of custody letter to be signed on Sunday, indicating that we had received the machines and the counts on the machines were received, and that the machines had been sealed. In this case, we were asked to sign the chain of custody letter on Sunday, even though the machines were not delivered until 2 a.m. in the morning on election day. The Milton precinct received its machines at 1 a.m. in the morning on election day. This is unacceptable, and voting machines should not be out of custody prior to an election day. Defendants have a duty to treat the voting citizens in each county in the same manner as the citizens in other counties in Georgia. As set forth in count 1 above, defendants failed to comply with the requirements of the Georgia Election Code and thereby diluted the lawful ballots of the plaintiffs and other Georgia voters and electors in violation of the United States Constitution guarantee of equal protection. Specifically, defendants denied the plaintiffs equal protection of the law and their equal rights to meaningful access to observe and monitor the electoral process enjoyed by citizens in other Georgia counties by A, mandating that representatives at the pre-canvass and canvass of all absentee and mail ballots be either Georgia barred attorneys or qualified registered electors of the county in which they sought to observe and monitor. B, not allowing watchers and representatives to visibly see and review all envelopes containing official absentee and mail-in ballots, either at or before they were opened and or when such ballots were counted and recorded. And C, allowing the use of Dominion Democracy Suite software and devices which failed to meet the Dominion certification reports conditioned for certification. Instead, defendants refused to credential all of the Trump Republicans submitted watchers and representatives and or kept Trump campaign's watchers and representatives by security and metal barricades from the areas where the inspection, opening, and counting of absentee and mail-in ballots were taking place. Consequently, defendants created a system whereby it was physically impossible for the candidates and political parties to view the ballots and verify that illegally cast ballots were not opened and counted. Many affiants testified to switching absentee ballots or mail in ballots for Trump to Biden, including a Democrat. He testified in his sworn affidavit that before he was forced to move back to where he could not see, he had in fact seen absentee ballots for Trump inserted into Biden's stack and counted as Biden votes. This occurred a few times. See Exhibit 18, paragraph 12. Other Georgia County boards of elections provided watchers and representatives of candidates and political parties, including without limitation, watchers and representatives of the Republicans and the Trump campaign, with appropriate access to view the absentee and mail in ballots being pre canvassed and canvassed by those county election boards, and without restricting representatives by any county residency or Georgia bar licensure requirements. Defendants intentionally and or arbitrarily and capriciously denied plaintiffs access to and or obstructed actual observation and monitoring of the absentee and mail-in ballots being pre-canvassed and canvassed by defendants, depriving them of the equal protection of those state laws enjoyed by citizens in other counties. Defendants have acted and will continue to act under color of state law to violate plaintiffs' right to be present and have actual observation and access to the electoral process as secured by the Equal Protection Clause of the United States Constitution. Defendants further violated Georgia voters' rights to equal protection insofar as defendants allowed the Georgia counties to process and count ballots in a manner that allowed ineligible ballots to be counted, and through the use of Dominion Democracy Suite, allowed eligible ballots for Trump and McCormick to be switched to Biden or lost altogether. Defendants thus failed to conduct the general election in a uniform manner as required by the Equal Protection Clause of the 14th Amendment and the Georgia Election Code. Plaintiffs seek declaratory and injunctive relief, holding that the election under these circumstances was improperly certified and that the governor be enjoined from transmitting Georgia's certified presidential election results to the Electoral College. Georgia law prohibits certifying a tally that includes any ballots that were not legally cast or that were switched from Trump to Biden through the unlawful use of Dominion Democracy Suite software and devices. Alternatively, plaintiffs seeking declaratory and injunctive relief, holding that the election under these circumstances was improperly certified and that the governor be required to recertify the results, declaring that Donald Trump has won the election and transmitting Georgia's certified presidential election result in favor of President Trump. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the declaratory and injunctive relief requested herein is granted. Indeed, the setting aside of an election in which the people have chosen their representative is a drastic remedy that should not be undertaken lightly, but instead should be reserved for cases, in which a person challenging an election has clearly established a violation of election procedures and has demonstrated that the violation has placed the result of the election in doubt. Georgia law allows elections to be contested through litigation, both as a check on the integrity of the election process and as a means of ensuring the fundamental right of citizens to vote and to have their votes counted accurately. OCGA 21-2 520. In addition to the alternative request for relief in the preceding paragraphs, hereby stated, plaintiffs seek a permanent injunction requiring the county election boards to invalidate ballots cast by 1. Voters whose signatures on their registrations have not been matched without ballot, envelope, and voter registration check. 2. All dead votes. And 4. All 900 military ballots in Fulton County that supposedly were 100% for Joe Biden. Okay, we're going to end there, and we'll pick up on part 9 very soon. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below, and we'll talk again soon. Bye.